Today's case has something bizarre that I'd never seen before. A judge read out the wrong ruling in court and sentenced the person to an extra 2 years that he never meant to impose. And this doesn't happen in just any case. This is the case of Peter Khill. Now, if you're not familiar with this case, Mr. Khill came out of his house to confront somebody who appeared to be breaking into his truck. A struggle ensues. He fires a shotgun twice and kills the person who is breaking into his vehicle. He claims self-defense, and at his first trial, he's acquitted. But the Crown appeals that, and it goes all the way up to the Supreme Court. The Supreme Court finds that the instructions the jury was given were improper, and he gets sent back down, and he is, at his new trial, convicted of manslaughter. Now, his team had asked for somewhere like 4 to 6 years, and the prosecution had suggested 10 years. Ultimately, the judge came back in court and sentenced Mr. Khill to a sentence of 8 years. And now, the judge says that was a mistake. He never meant to do 8 years. He meant 6 years. And not only that, but he's now sent in a letter on the appeal to say, oops, my bad. This is really messed up, not just because of the oops, my bad, or the fact that it took him like a year to do so, but some of the other details that are in this letter. So we're going to go through this letter. I got this via a CBC article. I'm going to link the CBC article as well. I'm going to commend them for actually linking the full proper letter. But let's have a read of it, because it has some interesting details that I think are in a lot of ways an indictment of the larger system. So let's have a read of this letter. I'm going to say I'm a little mixed on this one. I've got some praise for the judge. I've got some condemnation for the justice as well. I've got some thoughts. Okay, so here is the letter. And the letter is just notes, Dear Associate Chief Justice, regarding Khill. Okay. It says, I respectfully request that you consider this letter to the Court of Appeal as a trial judge's report akin to that which would be provided under the old criminal appeal rules regime. So something where the trial judge can indicate sort of what happened in court. I acknowledge that the timing and scope of this letter to the Court of Appeal may be somewhat unprecedented and is an extraordinary step in this criminal proceeding. As I said, I'd never seen this before. It may well be unprecedented. You don't typically see letters from the court saying, I screwed up. Please appeal my decision. This is weird. It says, moreover, I fully recognize that my role as trial judge is to speak from the bench and provide cogent reasons for appellate review. It is not to provide justifications for my actions after the fact. Normally, I have seen cases where a judge has written a letter or tried to intervene in an appellate process, but all of the ones I've seen, and this is, of course, highly inappropriate, where I've seen it, it has been a judge trying to say, listen, here's why you shouldn't overturn my decision. Here's additional information that supports my decision, and you should back it up. This is one of the I don't know if there's ever been another case where the justice has said, you should overturn my decision, but here we are. It says, nevertheless, I feel strongly compelled and duty-bound to bring to the Court of Appeal's attention what I believe to be 2 relevant errors committed by me during the sentencing hearing in this case. This criminal proceeding has an extended and well-publicized history. It's a case that's got national attention. In particular, as you are no doubt aware, the matter was returned back to this court for a second trial after the Supreme Court of Canada dismissed Mr. Khill's appeal from the Court of Appeal's decision. After a second trial with a jury, Mr. Khill was found not guilty of second-degree murder, but guilty of the included offense of manslaughter. In Canada, anytime they charge a crime, anything that is a lesser and included offense, which means that all of the elements of the smaller offense are included in the higher offense, then they can be convicted of that. So in this case, they found that there wasn't a specific intent to kill, but that there was a wrongful act that resulted in death. So lengthy submissions and volumes of materials were filed for the contested sentencing hearing. The Crown sought a 10-year custodial sentence, while defense counsel submitted that the minimum sentence of 4 years was the appropriate disposition. Throughout my analysis and preparation for delivery of my sentencing decision, I was of the view and resolved that the appropriate range of incarceration for this offense and this particular offender was between 6 and 8 years. So that's where the judge was kind of landing, somewhere between 6 and 8. My primary focus thereafter was determination of the exact number of years of incarceration within that range. In this regard, I recall that when working through most of my prior drafts, I had the disposition assessed at either 6 or 7 years. Eventually, premised on the rationale described in my reasons, including the substantial mitigating factors as detailed, and the substantial mitigating factors, he had a ton of support letters. He had no prior bad criminal, like no prior criminal acts. He's basically the guy coming at, being convicted of manslaughter is not a great place to be, but within that, he was basically in the best possible situation of, support, of no prior criminal activity, of no likelihood to reoffend, etc. So, my conclusion was that the appropriate custodial sentence for this offense and this particular offender ought to be at the lower end of the aforementioned range, i.e. 6 years. In advance of the sentencing hearing on June 6, 2023, I had 3 sets of written rulings prepared. Each were identical except for the final number of years of incarceration to be imposed. So basically he had 3 drafts ready to go and he grabs the wrong one. He says, "Yet on the day of sentencing, as I left my chambers, I inadvertently took the wrong set of reasons with me." It was only at the very conclusion of delivering my over 90-minute long sentencing ruling that I realized I'd adopted the wrong version as it related to the ultimate period of incarceration. In a momentary lapse of judgment, I read out the disposition of 8 years. In doing so, I misspoke. That was my first error. Okay, so at this point, this is just in the realm of, oops, things happen. And there was an appropriate response here, and unfortunately, the justice didn't take it. He says, "I confess that I was immediately nonplussed. While not an excuse, my ensuing inaction was perhaps due to a variety of factors, including having just read out a lengthy 53-page ruling before a crowded and divergent audience." Divergent is an interesting choice of words here. With substantial media presence for this high-profile case. Indeed, I did not react as I should have in the circumstances. What he should have in the circumstances is to just say, sorry, not 8 years, 6 years. 6 years is the appropriate sentence. An immediate correction while he was still on the bench, while everyone was still there. That was the proper response. And I'm reminded of the George Orwell story. I think it's called On Killing an Elephant or To Shoot an Elephant. I forget the exact title right this second. Talking about the effects of peer pressure. It might be hard to correct yourself when you're staring in front of a room, including the victims' families, who will be, who would have been very upset to see any sort of challenge there on that. So, that is itself one issue, but also the media. If he'd said 8 years, oops, 6 years, the media, of course, would have broadcast that. It's a tough thing to do, but that is exactly what we expect justices to do. It's kind of the job, right? It's kind of sometimes the job of a justice is to be unpopular. I will give him points for stepping up now to say I made a mistake, but now is not the ideal time. We're going to talk about that as well. It says, "Thus, the second error was my failure to stand the matter down or make an immediate indication admitting a mistake and/or properly correct myself and the record at the relevant time." Okay, now here is where he's also going to kind of give a bit of an indictment of the rest of the system. It says, in the immediate wake of that sentencing hearing, I consulted with several experienced judicial colleagues specializing in criminal law to discuss what steps I could take to rectify this error. I'd contemplated having counsel return before me to address the issue, either in chambers or in open court. However, I was dissuaded from doing so, as I was functus officio in relation to the matter, and the overall sentence imposed was entirely within the scope of the prevailing jurisprudence. Okay, so let's discuss this. Functus officio is Latin, and it basically means you're done. It's not exactly the translation, but it basically means you're done here. And what that means ultimately is that a judge, once they've completed the case, they don't get to tinker with it. So as kind of a big example of this, let's imagine that there's a a drunk driving causing death, and the person goes and they get sentenced and they get 5 years in jail, just as to pick a random number. They should probably get more, but let's say they get that because they've got really good mitigating circumstances and so forth. Well, after the sentence is passed, the guy goes and gives a press conference in which he says, yeah, that judge was real dumb. I'm a total bad, I will do it again. I'm a bad person. and I'm proud of it. Well, now the judge might regret the 5-year sentence and really wish that they'd given maybe a 15-year sentence. But they can't. The judge is done. It's over. If the Crown wants to seek the higher sentence, they'd have to appeal it and take it through that process. But you can't just keep going back to the judge. Eventually the judge is finished. The case is over. So that's functus officio. And so what the judge is saying here, the justice is saying, is that they were told by their colleagues that they can't go and try to correct this because they're finished. But I think it would have been appropriate for them to indicate to the parties to say, hey, am I functus officio in your opinion? Like, what's the situation here? And also, this is the mistake. This is the error. Because I suspect that if they'd indicated that right away, that this would have facilitated an appeal. This wouldn't have come so far and so late into the process. But similarly, what he's saying here, what this justice is saying is, listen, my colleague said, well, the sentence is fine. Don't touch it. Just leave it be. Even though it's a mistake, it's just keep it quiet. Shh, don't tell anyone. And to me, that is the opposite of what should be going on in the halls of justice. Because if the sentence was a mistake, if it was an error, and clearly this justice is, torn by it, has some concern, then why would the other justices say, oh, just keep quiet? That, to me, is a huge problem, and those justices ought to be ashamed. The particular justice that wrote this letter evidently screwed up, and I don't like the screw up. I don't like that the justice didn't immediately take steps to correct it. None of that is good. But I will give the justice credit for stepping forward to say, listen, an injustice is happening here, and I need to try to fix it. And doing so at great personal embarrassment and great so it would have been super easy for this justice to follow that advice that they were given and just keep their mouth shut and just not say anything. And I will give the justice credit here for having the moral courage to stand up and step up and say, no, something is wrong. I'm going to do something about it. The best time to do the right thing is in the moment. But the second best time is now. And so it is often harder to do the right thing later. And so I will, Yeah, I don't like that this happened, but I give tremendous credit to the justice for trying to step up and try to correct this. Now, this to me is a big, big problem because now you've got somebody who is sentenced to the wrong time. How do we fix this? Do we impose the original 6 years? Do we impose the original 4 year or the 4 years that the defense is seeking? I haven't seen, this is sort of very recent. I haven't seen yet, and I'm going to try to get the prosecution's response to it. I'm going to try to get their, what they've said in reply, because I suspect, and I hope that I'm wrong on this, but I suspect that the prosecution's reply will be something along the lines of, listen, this is irrelevant, and therefore, therefore there's just nothing to be done here. Ignore it and keep the current sentence. And to me, that would be a profound injustice. We should be sentenced based on what we did, not based on, the court's mistake. And if the court's mistake gets Mr. Khill an extra 2 years, I don't think that's right. So let me know what you think in the comments below. I've sort of shared my thoughts here, but I want to hear what you guys have to say. This is a tough one. And yeah. Anyway, thank you guys for watching. I hope you found this to be interesting or educational. If you have, please hit the like button, share, subscribe, all of those good things. I also have a link to my Patreon below. If you want to contribute via that means, there's a link. I also want to thank my supporters there at the $50 level. CCFR, Canada's National Firearms Association, and I've got to sort... CCFR, Canada's National Firearms Association, Bottle Shock in Oz, PJs Forever, CMP, Cielo, and Purple Dragonair. And at the $20 level, Mark, Lindsay Metcalf, Larry Kalniak, Kyle Fox, Drunk All of the Baileys, Cameron Johnson, Andrew Elsich, Marvin CZ, and Dorky Dane. Thank you as well to my $10 supporters who will be in the crawl immediately following. Thank you for watching. Hope this has armed you with knowledge. See you next time.